There's new action coming out of Washington that stands to affect hundreds of thousands of people around the world trying to join family in the United States. These are yet more changes from the Trump administration on family-based immigration, or rather legal immigration. It is especially for families waiting on permanent residency for spouses, children, or parents. In this video, we'll go through what's changed, how the pause works, who it applies to, pause, and what you need to know if your green card case is already in motion or still in the queue. As 2026 unfolds, one of the most significant immigration developments involves the processing of green card applications, especially those filed for family-based visas. The U.S. government has effectively placed a hold on certain types of immigrant visa processing at U.S. consulates and embassies abroad, and has directed agencies like U.S. Citizenship and Immigration Services (USCIS) to re-examine how these cases are being handled. The changes also affect the pace of processing for green cards submitted by certain categories of applicants, including some family members of U.S. citizens and lawful permanent residents. This action stems from a combination of administrative directives and policy memos issued late in 2025 and continuing into January 2026, which collectively impose a temporary pause on the processing and issuance of immigrant visas for nationals of multiple countries while agencies review screening protocols and eligibility standards. The pause affects a wide range of immigrant permanent residency applications at the consular level. The so-called pause was implemented to give the Department of State and associated agencies time to tighten vetting procedures and ensure that applicants meet the criteria the administration has emphasized, including financial stability and other requirements. The most visible element of this policy is the announcement that beginning January 21, 2026, immigrant visa processing for nationals of a set of around 75 countries has been paused indefinitely. This includes family-based immigration visas issued at U.S. consulates and embassies around the world. While the pause does not affect every immigration case across the board, it does directly impact many family-sponsored categories at the overseas visa issuance stage. To be clear, this pause generally refers to the consular processing stage, the point at which an approved immigrant petition and available visa number lead to an appointment abroad for a visa interview and eventual issuance of a green card visa. Under this new directive, consular officers are being instructed not to issue immigrant visas for nationals of the countries covered by the pause, while additional review and public charge screening criteria are finalized. Many family-based green card applicants go through a two-step process. First, a family member in the United States, often a U.S. citizen or lawful permanent resident, files a petition on behalf of the relative seeking permanent residency. That petition, such as an I-130 for a spouse, parent, or child, must be approved by USCIS before the case moves forward. Once USCIS approves that petition and a visa number becomes available based on the applicant's category and priority date, the case typically moves into consular processing if the beneficiary resides abroad. It is at this final step, consular processing, where the pause comes into play. The policy does not mean that USCIS is refusing to accept or review I-130 petitions. Those initial family petitions continue to be processed in the United States. But once the petition is approved and the case is ready for visa issuance abroad, consular offices are not currently issuing immigrant visas for nationals of the designated countries, while the pause remains in effect. This has created uncertainty and significant delays for family members who had expected a smoother path to lawful permanent residence. The list of countries affected by this pause includes nations across Africa, Asia, the Caribbean, and Latin America. Some examples listed in public notices and reporting include Afghanistan, Bangladesh, Brazil, Colombia, Cuba, Ethiopia, Haiti, Iran, Nigeria, Russia, Somalia, and Yemen, among many others. Those from these countries who have pending immigrant visa applications at U.S. consulates are being notified that their interviews may be postponed or that their visas will not be issued until the pause is lifted and the administration completes its review of screening protocols. It's also important to understand what the pause does not affect. Temporary non-immigrant visas, such as tourist B1, B2, student F, exchange visitor J, and employment H1B categories, are not included in this pause. These visas continue to be issued by U.S. embassies and consulates in most cases. Additionally, the pause on immigrant visa issuance abroad does not apply to individuals already inside the United States who are pursuing adjustment of status through USCIS. In other words, if someone is physically present in the U.S. in lawful status and eligible to adjust status to permanent residency, the pause at consulates does not prevent that adjustment from progressing under USCIS procedures. This distinction means that the policy's immediate effect is most pronounced for family members waiting outside the United States who have been relying on consular processing to complete their green card journey. Those living in the U.S. with pending adjustment cases are generally not subject to the same pause. Although backlogs and administrative delays can still slow processing timelines, officials have framed the pause as a necessary step to ensure that immigrant visa issuance aligns with updated screening standards, particularly the so-called public charge considerations, which relate to whether an applicant is likely to rely on government benefits. The State Department and Department of Homeland Security have expressed concerns that existing protocols might not adequately identify cases that do not meet these updated standards, which is why they've instructed consular officers to delay visa issuance pending a review. Critics of the policy have pointed out that family-based immigration has traditionally been a cornerstone of U.S. immigration law, designed to keep families together and promote family unity. The pause on immigrant visa issuance, particularly for nationals of 75 countries, could separate families or prolong the separation of spouses, parents, children, and other relatives waiting to join their loved ones in the United States. These delays can affect long-term plans, employment opportunities, and even housing arrangements for families who expected to reunite under more predictable timelines. In addition to family-based immigrant visas, some reporting suggests that other immigration benefits, including asylum applications and certain adjustment cases tied to related travel ban countries, have seen processing holds or enhanced review requirements under recent policy memos issued by USCIS. These internal matter indicate that benefit applications filed by individuals from countries on the travel ban list or related expanded lists may be subject to additional vetting and review before decisions are issued, further complicating the immigration pathway for affected applicants. What this means going forward is that many family immigrant visa cases that have been progressing through consular processing will remain on hold until the Department of State and related agencies announce a change or lift the pause. Applicants and petitioners are advised to monitor official communications from U.S. embassies, consulates, and government agencies, and to maintain current contact information so they receive updates about their individual case status. Attorneys and immigration practitioners are also recommending that families explore adjustment of status options if they are eligible and present in the United States, as that pathway remains intact despite the pause abroad for the larger immigration system. This pause represents one of the most significant slowdowns in family-based immigrant visa issuance in recent years. Whether the pause will be brief or extended depends on how quickly the administration completes its review of screening procedures and how policies evolve in response to legal, political, and diplomatic pressures. Meanwhile, family members waiting abroad are left in limbo, waiting, planning, and hoping for clarity.